Good morning and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Tulo Hoyani. Yesterday we saw another unfortunate altercation between Judge Ratam Khwatling and Advocate Munisi just towards the close of proceedings. I've always lamented these altercations and I've said times without number that they are uncalled for. The decorum of the court is important. And that is what disturbed me when I saw what happened between Advocate Munisi and Judge Ratam Khwatling yesterday. You'll recall that Judge Baloyi now wants to lead the evidence, the confession statement. Judge Baloyi wants to confront Muzi Sibiya with the alleged confession made by Ntanzi significantly before Magistrate Cronje. So it was at that stage when Baloyi attempted or indicated to the court that he intended to lead to cross-examine Muzi Sibiya on that confession statement, that Advocate Munisi then stood up to object. He was immediately cut out by the judge in a very curt manner. The judge just simply told him to sit down. Munisi then sat down. At a later stage, when Baloyi had finished making his submissions, the judge then called upon the defense counsel to get their side of the story. Advocate Munisi, being the first one, declined to take that opportunity and got into that altercation with the judge by telling the judge that, I'll not say anything, you have cut me out, you have cut me out. It was an ugly scene that does not belong in any courtroom. So it was then that Advocate Munisi, subsequent to that, just sat down. And this was, in my own view, very unfortunate. Because you see, altercations like that, to start with, are unnecessary and do not belong in that courtroom. And secondly, Advocate Munisi must not be in the habit of sulking. You see, because that was sulking when he just decided that, no, I will not say anything anymore because I have previously been shut down. Because you see, whatever happens to a defense counsel, you are there in the first place on behalf of the person that you are representing. Now, if you simply sulk and say, well, I will not say anything anymore, you are simply jeopardizing at the end of the day the defense of your client. So Advocate Munisi should not have resorted to that kind of conduct because it is unhelpful for Muzi Sibiya's defense. Anyway, that is how it went. But the real business of this morning is to address that issue that Advocate Baloyi is taking up. You see, Advocate Baloyi is relying on a confession allegedly made by Ntanzi, accused number 2. It was as a result of that alleged confession by Ntanzi that all the other accused persons were then arrested. Presumably, after he had implicated them in the commission of the crime of killing Senzo MEYIWA. So Advocate Baloyi is now coming up. Advocate Baloyi is coming up with this confession to confront Muzi Sibiya about it. To in effect say to Muzi Sibiya, this is what Ntanzi said about you. This is how your own co-accused has connected you with the commission of this crime. Now, let us glance back a little bit and say to ourselves and look at the trial within a trial and begin by saying that Bongani Ntanzi has always vehemently denied that he ever made a confession before Magistrate Cronje. He has testified that whatever it was that he was possibly made to sign purportedly by Magistrate Cronje was something that was unknown to him. So in effect, Bongani Ntanzi is distancing himself away from the so-called confession that Baloyi seeks to rely upon. Now, if you take matters back to the trial within a trial, you will all recall that the court made a ruling insofar as those confessions are concerned. And that ruling was to the effect that those confessions had been made freely and voluntarily by, among others, Bongani Ntanzi. Because this is the confession that we are now focusing upon. So the court has already pronounced itself on this issue, that those confessions were made freely and voluntarily. But that does not preclude the defense, or that does not, prevent the defense from challenging the line that Advocate Baloyi wants to take of cross-examination. Because confessions in law are inadmissible as against other persons. They are only admissible against the maker of such a confession. And the court having ruled that these confessions were made freely and voluntarily, the next leg of that inquiry now is, if these confessions then can be said to have been made freely and voluntarily, are they by extension also admissible as evidence against Bongani Ntanzi's co-accused? In other words, let me simplify it by saying this. If the court has made a determination, like it has already made a determination, that this confession by Bongani Ntanzi was made freely and voluntarily, the next question will then be those disclosures or the content of that confession. To the extent that those disclosures or the contents thereof implicate all the other accused persons, can such evidence then be admissible against the other co-accused? So that is a crucial issue that is before the Pretoria High Court. Now, let us look at the law for one moment. In terms of the law, in terms of Section 219 of the Criminal Procedure Act of 1977 as amended, confessions are inadmissible against other persons. They are only admissible, in respect of the person or against the person who is making that particular confession. So if we take the situation of Ntanzi, for instance, if Ntanzi has said, I, Bongani Ntanzi, in that confession, which is disputed, by the way, if Bongani Ntanzi says, I, Bongani Ntanzi, was involved in the murder of Senzo MEYIWA, that is a confession. Now, I was also involved in the killing of Senzo MEYIWA with so and so. what then do we make of such evidence? Can such evidence be admissible against his own co-accused? So Section 219 of the Criminal Procedure Act says such a confession can only be used as evidence against the maker of the confession, the person who actually makes that confession. That is what the Criminal Procedure Act says. But then there are complications around this. It does not end there, because we also have the Law of Evidence Amendment Act, I think it's Act 45 of 1988. That act deals with hearsay evidence. It deals with hearsay evidence. And confessions become relevant here because confessions are by their very nature hearsay evidence. Because if Bongani Ntanzi confesses to a magistrate cronier, that evidence that he is giving to magistrate cronier, right, if tendered by magistrate cronier herself or any other person in possession of that confession statement, that becomes hearsay. It is a hearsay of Bongani Ntanzi. So this is how I am bringing the issue of hearsay into play here. Now, the Law of Evidence Amendment Act of 1988 says such evidence, such hearsay evidence, can be admitted by the court if, with a proviso, among other things, that if it is in the interest of justice to have such evidence admitted. Now, it is a question of fact, it's a question of evidence what the interests of justice are. And this will vary from case to case. But like I have said, as a general rule, confessions are only admissible against the maker of the confession. So the argument this morning that Baloyi is going to advance is premised on the Law of Evidence Amendment Act of 1988, wherein Baloyi is going to say, this is hearsay evidence. These confessions, he's going to begin this way. He's going to say, these confessions were deemed to have been made freely and voluntarily by this court during the trial within a trial, in spite of the fact that they are hearsay evidence against Bongani Ntanzi's own co-accused. It would be in the interests of justice to admit such evidence. And the court will then have to make a determination thereon. What a tricky situation this is going to be. So the defense will then have to argue that it is not in the interest of justice. It would not be in the interest of justice to do that, because if, for instance, that hearsay evidence, which is the subject matter of the confessions themselves, is then admitted in the interest of justice in terms of the Law of Evidence Amendment Act, how then do the accused persons, right, who do the accused persons cross-examine? Because you see, the maker of hearsay evidence can only validate hearsay evidence by himself or herself coming forward to testify. Otherwise, that hearsay evidence does not stand. And in this case, there is no way that Bongani Ntanzi is going to come forward to come and agree or endorse a confession that he has always disputed. Now, who does, or what is the defense left with? Who will the defense, under the circumstances, cross-examine to establish the truthfulness of, or the veracity, the overall veracity of the contents of that confession? Because Bongani Ntanzi is not going to come forward and vouch for a confession that he has always disputed. And therefore, the defense will not get an opportunity to cross-examine him because he's not going to be coming forward. So it all sounds like Greek sometimes. But these are the issues that the Pretoria High Court will be looking into this morning. And we just hope that those tantrums between, Judge Tamu and Advocate Muzi somehow abate, so that we can focus on the real issues. Let us wait and see how it goes this morning. I hope they don't adjourn early like they usually do. They have got this habit of waking half days on Friday. I don't know where that comes from. Let us wait and see how it all pans out this morning, and in a later edition of the Daily Fix, or in the next edition of the Daily Fix, I'll then bring you an update on the proceedings of the day. Thank you very much, and have a wonderful, wonderful start to the weekend.